Vamos a continuar con el tema comparativo para América Latina del régimen de garantías en el seguro marítimo frente a Marine. Tenemos a Geoffrey Collin, él es partner en Holman, Fenwick & Whelan, también consultor extranjero de Cala Abogados en Brasil. Es un abogado inglés que asesora a clientes en materia de seguros y reaseguros, comercio internacional, envíos y asuntos offshore en áreas contenciosas y no contenciosas. Tiene un interés específico en el seguro marítimo, especialmente en puertos y terminales. Geoffrey es recomendado en los directorios de la Cámara Latinoamericana con clientes, destacando su conocimiento muy directo y también la comprensión de los mercados locales, además de todos los temas de coberturas en los seguros. Geoffrey, bienvenido.
Muchas gracias, Javier. Una presentación excelente. I'm going to speak in English. I hope that's okay. I see Charlotte's laughing at the front. I'm going to talk about marine insurance warranties from an English law perspective in the context of the Marine Insurance Act 1906 and newer legislation, the Insurance Act 2015. I'm going to have a look at what happens in Latin America. Here's the agenda. So we're going to look basically at the anatomy of an insurance policy. We're going to look at what are warranties, how do you identify one, what are basis of the contract clauses. These are peculiar English. This is a peculiar English idea. We're going to look at the effect of breach of warranty in our old legislation. We're going to touch on what happens in Latin America, not in any depth, because there's going to be some panel discussion about that. And then we're going to look at what are the recent English law reforms under the Insurance Act 2015. Now, an insurance policy is like a cake. It's like a contractual cake with lots of different ingredients, like warranties, conditions precedent, conditions, and we're going to take a look at some of the main ingredients with a specific focus on warranties. When we look at the anatomy of an insurance policy, we look at the classification of terms, and we see the insuring clause, which basically lists the insured perils, and the policy, like the Institute cargo clauses A, may be all risks, or it may be a name peril policy, like the Institute cargo clauses B and C. In addition, there'll be excluded perils. Well, they're self-explanatory. You'll also have uninsured perils, where the policy is silent as to whether there's coverage or whether there isn't. In addition, there are triggers of coverage. These require satisfaction before coverage is triggered. So, for instance, that might be receipt of premium or classification of a vessel or receipt of a proposal form. You then have continuing obligations, which vary according to the nature of the cover, but it may be, for instance, maintaining security devices or acting without negligence or restrictions on the use of property. And finally, you have claim provisions, and these might include, for instance, contractual timeframes for the notification and payment of claims, claims cooperation clauses, especially in liability policies, mitigation and subrogation clauses. Now, looking at the classification of terms used in most common law jurisdictions, we look at warranties, which we're going to focus on later. We also have conditions precedent to the risk of cover. We have another type of conditions precedent, and that's a conditions precedent to liability. And then we have contractual conditions, which have been imported from our normal non-insurance law, which includes conditions which go to the root of the contract, ancillary terms, which are distinguished from a condition because they're terms that don't go to the root of the contract, and we have innominate terms, which may be a condition or maybe an ancillary term, and we'll come on to that. So there's quite a few ingredients in this contractual cake. In terms of breaches, well, breach of warranty, the insurer is discharged from liability from the date of breach. And we're going to come and look at that in more detail later. But for the time being, two important things to remember. First of all, it doesn't matter whether or not there's any connection between the breach and the loss. You're still discharged from liability in the event of breach. And secondly, it doesn't matter if the breach was remedied prior to the loss. And that's the status under our Marine Insurance Act 1906. In terms of the breach for breach of condition precedent to the risk of cover and breach of condition precedent to liability, these are basically, in the second case, it will preclude the claim. And in the first case, it precludes the attachment of cover in the first instance. So unless the provision is complied with, the insurer is just discharged from paying the claim, or the policy doesn't actually incept where the condition precedent is to the risk of cover. In terms of contractual conditions, well, the remedy for breach of a condition is if it's a repudiatory breach, the insurer has the right to terminate the contract and sue in damages. Alternatively, he can affirm the contract, so he has a right of election. Repudiatory breach is very common in sale of goods contracts like GAFTA, phosphor, all of that stuff. It's very rare in insurance law. And importantly, in order to establish a repudiatory breach, that breach must go to the root of the contract. As regards an ancillary term, if there's a breach, you cannot terminate the contract, you just sue in damages. And if there's an innominate term, this may be a condition or it may be an ancillary term. The claim is basically incapable of classification, so you wait and see how serious is the breach, and you look at the consequences. And if the consequences of the breach are serious, you may be able to repudiate liability, terminate the policy because it's a condition. Alternatively, you may be able to sue in damages as an ancillary term. Now, turning to warranties, which is one of the first ingredients at the top of our list, let's give some practical examples to contextualize it. You may see, for instance, in cargo policies, warranties as to quality, condition, and packaging. In hull policies, you may have class warranties, navigation warranties, survey warranties. There are implied warranties as to seaworthiness and legality in our Marine Insurance Act 1906. In some ports and terminals policies or warehouse policies, you may have fire alarm and security warranties, or warranties about the existence of sprinkler systems. And in many slips, certainly in the London insurance market or reinsurance market, you'll have warranted KNORL, warranted no known or reported losses. There is a partial definition of warranty at Section 33 of the Act, and I'll read this out because it's important. The assured undertakes that some particular thing shall or shall not be done, or that some condition shall be fulfilled, or whereby he affirms or negatives the existence of a particular state of fact. So it really defines the scope of cover. Importantly, under the old Act, it must be exactly complied with, whether it's material to the risk or not, and if it's broken, the assured can't argue that he remedied the breach prior to the loss. So what is a warranty and how does it operate in practice? Well, we can go back to 1786. There's a very old case which demonstrates quite well how this works and how potentially unfair it can be. In this case, a ship was to leave Liverpool with 50 hands or upwards, i.e. with 50 crew members. There was a substantial risk of piracy, and this was known not just to the carrier but to the underwriter as well. The ship left Liverpool with a crew of 46, and before leaving British waters at the Isle of Anglesey, it picked up another 6 crew members. So at this stage you have 52 in total. The vessel then leaves British waters, is captured and lost off the coast of Africa. The insurer refused to pay the claim for breach of the crew warranty, and the court agreed, saying that warranties had to be complied with exactly. If there's a breach, the insurer is discharged from liability from the date of the breach. And it was immaterial in this case that the breach was remedied within a few hours of setting sail from Liverpool, and a long time in advance of the loss actually happening. It's an old case, but its finding has been codified in our Marine Insurance Act 1906, and it demonstrates how warranties operated up to that time and continue to do in many cases. So just a recap, really. The substantive law on English law warranties derives from 17th and 18th century marine insurance markets. Warranties were especially important at a time when the condition and safety of the insured object might be unknown and maybe many miles away, and the relevant devices, communication devices we have nowadays simply weren't available. Warranties define circumstances in which the risk attaches and continues to attach, and importantly, they dispense with issues of proof and remove the need for any causative analysis. So we've looked at the partial definition at section 33.1 of the MIA, and it gives you some idea how difficult it is to identify a warranty. Further clarities in this case, HIH casualty and general insurance. Now this wasn't a marine case, it was a film finance case, and I remember when I arrived at my firm, we were working on this case. And the judge said, when looking at how to identify a warranty, he said, it's a question of construction, and the presence or absence of the word warranty or warranted is not conclusive. So the test is one of substance over form. You look at the effect of the words, you don't look at the words themselves. In a nutshell, there's no precise science when you come to identify a warranty. It's very fact-specific. The judges took, under our old law, a very interpretive approach, and there's considerable confusion regarding the classification of terms. I want to move on now to basis of the contract clauses, which I said were a peculiar aspect of English law. Basically, these arrive in a scenario where the proposal form may say, this proposal form forms the basis of the contract. Now, the effect of that, under English law, is to convert all statements in the proposal form into warranties. So, in the event of breach, the insurer is discharged from liability, irrespective of causation and materiality. Judges in England have criticized this for a very, very long time, one describing these basis of the contract clauses as a trap, allowing insurers to refuse claims for minor or irrelevant mistakes. Its obvious one-sidedness is demonstrated by the following case called Dawson's and Bonin. And this involved a furniture removal firm who took out insurance on a lorry. In the proposal form, the policyholder gave the business address as being in central Glasgow, and in answer to the question about where is the lorry usually parked, the policyholder, he said, inadvertently wrote at the above address. However, in fact, the lorry was parked on the outskirts of Glasgow. The policyholder argued that this wasn't a material fact, it didn't increase the risk, and the insurer pointed out that the proposal form provided that the policyholder's answers formed the open inverted commas basis of the contract. And the House of Lords held that this basis of the contract clause converted the policyholder's statements into warranties, and the insurer could use the policyholder's mistake to refuse all claims under the policies. This is obviously unfair, and you'll see that our new Insurance Act addresses these clauses head-on. Turning to the effect of breach of warranty. Well, as we said, the insurer is automatically discharged from all future liability from the date of breach. Now, this isn't the same as avoidance of the policy ab initio, and it's not the same as termination of the policy. The warranty requires exact compliance. Materiality or connection with the loss is irrelevant, so a breach of warranty associated with one risk, like fire, will discharge the insurer for loss of another kind, like flooding. Importantly, repair of the breach does not reattach the cover, and the harshness of this provision is demonstrated by a premium payment warranty, for instance, where the policyholder is required to pay premium on a specific date. Now, if the policyholder is a couple of days late, although the policyholder has remedied the breach, he is still technically without cover, and even worse, he's still technically required or liable for future installments of premium. One additional point is that breach of warranty can be waived by unequivocal representation by the insurer of that, for instance, he won't rely on the breach. So what are the problems with the old law? Well, firstly, the insurer can refuse a claim for a trivial mistake which has no bearing on the risk. Secondly, the insured cannot use the defense that he remedied the breach. Thirdly, breach of warranty discharges the insurer from all liability, not just liability for the loss in question. So we go back to the flood versus burglar alarm scenario. Fourthly, goes to the basis of the contract clauses. They seem to be extremely unfair. And finally, we arrived at a scenario where the court was moderating harsh law through creative interpretation. And one such case is Clerc Knitwear versus Lombard General Insurance Company. Now, in this case, the policyholder's sprinkler system had to be inspected 30 days after renewal. The terms of the warranty were very clear. It was expressly stated in the policy to be a warranty, and the policy set out the consequences of the breach. Non-compliance would bar a claim, and the policy said whether it increases the risk or not. So hard to imagine clearer drafting. What happened was inspection took place 60 days late and showed the system was working. The factory suffered storm damage, so nothing to do with a fire, and the judge could or should, if he, on the strict letter of the law, have construed that condition to be a warranty and discharged insurers from liability. However, he didn't. He said, no, this is a suspensive condition. So breach of the clause suspends liability whilst the breach is in progress, and does not discharge the insurer from liability from the date of breach, as under the usual rules. So the judge found his own fair and reasonable conclusion on this case, on the facts of the case. However, the difficulty is it leads to uncertainty and complexity, which is not what you want when you take a claim into court. So leaving English law aside for the moment and concentrating on other common law jurisdictions, most jurisdictions moved away from the UK approach. Australia and New Zealand, who originally adopted statutory law equivalents very close to our law, both enacted reforms, and both laws required a causative link between the breach and the loss. In Canada, similar movement away, the loss must be material to the particular type of loss in order to found an actionable breach of warranty. In the USA, insurance laws left to each state, but certainly in New York, breach of warranty will only avoid an insurance contract if it would materially increase the loss. I did do some research on some of the Latin American jurisdictions, and these are the contributors to the work. I'm not going to dwell on the Latin American jurisdictions, primarily because I'm not qualified in any of these jurisdictions, even though I do live in Brazil and consult to a Brazilian law firm. However, what I will say is that it seems, in a nutshell, that warranties don't exist in Brazil or in Ecuador. They do appear to exist, and we're going to come on to this in the panel session, in Argentina, Chile, and Colombia. Certainly in Chile and Argentina, those laws require a causative link between the breach and the loss. Colombia is an outlier in that respect. None of these jurisdiction clauses, and this is of no surprise at all, have any law at all on basis of the contract clauses. They are, as I said, a peculiarly English thing. And under most of these local LATAM laws, you can't contract out, or you can, but it must be more favorable to your assured, to your policyholder. So Brazil, no Brazilian law equivalent. Moving quickly into Colombia, this is going to be interesting, and we'll come on to this later. That definition looks almost identical to our definition under the Marine Insurance Act, under Section 33. We'll talk about that later. And Ecuador, like Brazil, has no insurance law on warranties. So going back to English law, well, the UK finally woke up and realized that it was at a competitive disadvantage against the other jurisdictions. And they founded a case for reform. They've been doing this for ages, but finally somebody in the Law Commission, who was lobbied by various people, including a number of people from the market who are in this room, proposed reform in order to bring the London market back into line with the rest of the world and to address uncertainties with clarity and consistency. So our Insurance Act, which does apply to marine insurance, was enacted in February 2015, came into effect in August 2016, and applies to all policies entered into after that date. It covers various things, including the duty of fair presentation, but as regards warranties, it made three main changes. Firstly, it abolished the basis of the contract clauses. Secondly, it provides that breach of warranty suspends rather than discharges the insurer's liability. And thirdly, where terms are designed to reduce the risk of loss of a particular type, they should not affect losses of a different kind. Okay, and we're going to explore each of those very briefly. Basis of the contract clauses, that's the easy bit. This is Section 9. They're now of no effect. However, insurers can still protect themselves in two main ways in relation to what a policyholder writes in a proposal form. The first is the law of misrepresentation and non-disclosure, much loved by lawyers, including me. And this, of course, is part of a wider duty of the policyholder to give a fair presentation of the risk. And if they don't, under our old law, you could avoid the policy ab initio. Now we have proportional remedies that are actually much closer to what happens in Latin America. Secondly, they could protect themselves by using warranties of past or present fact included specifically in the contract of the policy, as opposed to having some wording at the bottom of the proposal form. The second main reform goes to the regime for breach of warranty. Now, as I've said, the insurer's liability is suspended rather than discharged in the event of breach. Liability can be restored if the breach is remedied. If the breach is remedied before a loss, the insurer has to pay the claim. However, if the loss occurs after the breach, but before the remedy, the insurer is not liable for that loss. The law recognizes that some breaches are incapable of remedy. In those circumstances, the liability remains suspended. Now, the importance of this change can be referenced by illustration to that Dahan and Hartley case about the ship that went to Africa. That would have been decided very differently now, because, of course, the breach was remedied whilst the vessel was still in English waters, sailed to Africa, got captured, insurance claim, insurers would have paid. Now, importantly, we move on to the third reform, and this is the insurer's liability for different types of loss. The focus here is on warranties which are designed to reduce the risk of a particular type of loss, or the risk of losses at a particular time or in a particular place. And basically, what this reform is trying to do, it's trying to establish some kind of relevance between what the warranty was intended to protect and the loss that actually happened. So, for instance, breach of a warranty to install a burglar alarm would suspend liability for loss caused by an intruder, but not for flood loss. That's the situation under the new law. Or a failure to employ a night watchman would suspend insurers' liability for losses at night, but not for losses during the day. Interestingly, the Law Commission rejected what we call the causation test, which is what you see in a lot of the other laws. And this section is really based on relevance, not on causation. They resisted causation for two main reasons. Firstly, they felt that some breaches of warranties may be relevant to the loss without having a connection to it. So if you look at the second example there, and the fact that an employee has past criminal convictions doesn't necessarily cause future misdemeanors, but it may be a highly important consideration for an underwriter. And secondly, the Law Commission veered away from the causation test in favor of the relevance test because causation is surprisingly complex. It's very fact-specific, gives rise to increased investigation costs and uncertain outcomes, and they wanted to move away from that. However, in practice, whether you use a relevance test, as we do, or a causation test, as many of the Latin American jurisdictions do, you should get to the same result, save for in limited circumstances. Now, a couple of minutes left. Just a couple of other issues. You can contract out of these provisions and make alternative arrangements. However, you do have to satisfy what we call transparency requirements, and that is to say you must make sure the terms are clear and that they're brought to the insurer's attention. And if you look at some of the P&I clubs in the international group, 9 of them or 8 of them still contract on English law. They have actually contracted out of these provisions. As regards definition of warranties, the new Act doesn't address that. So we've still got this uncertainty. I think this is a gross omission in the new legislation, but we've still got this uncertainty of what actually is a warranty. Yes, there is a requirement for marine insurance policies to be in writing. Are there any case law developments? Not yet. Not as far as when I checked this morning, there weren't any. And these provisions are relevant equally to reinsurance as they are to insurance. So, I've taken this from Robert Merkin, who formulated the following test for enforcement of a warranty under the new Act. And it is surprisingly complicated. First of all, you ask, is the clause a warranty at all? If not, you're looking at a different ingredient to the contractual cake altogether. So forget about warranties. Is there a breach at the date of loss? If so, you can take the analysis further. Does the warranty define the risk as a whole? If so, you don't look at the Section 11 requirements. Then you move on to the Section 11 requirements. Does the warranty tend to reduce the risk of any loss? Is the risk reduced one relating to its kind, place, or time? Could non-compliance have not increased the risk of loss that actually incurred? These are difficult questions. And then finally, you get to the final question, and you look at whether the parties have provided for any other agreement. Have they contracted out of the Insurance Act 2015? And that's all I've got for you. So we're now, I think, going to do a short panel discussion, and I'm very interested to hear what is happening in Venezuela, in Colombia, and in Argentina in terms of the operation of these warranties.